Oh, so hey guys, in my last video I was talking about a possible theory I may have on what Lively, if she's going to do anything at all, what her and her team may do. So I had a bit of a eureka moment when I was going through one of the Jed Wallace filings, actually. Not the filing, when I was doing one of my videos. Yeah, the last video on section 47.1, last week I think I did it. And I was saying, well, it's not unreasonable for Jed Wallace to file for defamation based on the fact that Lively lumped him in. And when I heard myself say lumped in, I was like, ah. And I thought about it. And when I went back through filings. So we've heard Lively talk on the red carpet in several interviews about this kind of unhealthy, codependent relationship she has with Ryan Reynolds, who seems to be quite needy. And we've heard her describe, how they kind of influence each other's work. They work on each other's projects, and they basically can't be apart. And she kind of implies that they're basically joined at the anus. And then I thought, okay, let me just go back through the filings and see. And this is one of the earlier ones. This was before Wayfarer even amended their complaint. It's January 24th, 2025. And I looked at a bit of a pattern here, which this has been at. Now, let's look at the lawyers, right? We've obviously got Gottlieb. He works in Wilkie, and everyone's like, well, Lively's written to the judge recently and said, look, I need an extra 30 days because he's basically, sitting on a sunbed somewhere in Aruba. Just to be clear, I don't know where he is or why he's away, but I'm just being a bit snarky here. But, but Lively's written recently, asked for an extra 30 days. Lyman gave her an extra week and said, basically, kind of get your shit together. And we all were like, right, okay, what's going on here? What is she trying to do? How is she going to try and pad the fees? Because we have some comparable situations. So the New York Times, who basically did the same thing with the same complaint and basically got themselves dismissed for a cause of action, a defamation cause of action from a Wayfarer complaint. They are seeking $150,000 for successfully defending that lawsuit. And that's under anti-SLAPP. Now, anti-SLAPP means they get their reasonable attorney's costs and fees, right? That's exactly what Lively's got. It's, got the title of Section 47.1, but really it's effectively, a anti-SLAPP award that, is basically got false eyelashes and nails on it. So we've also got Leslie Sloan, right, who was seeking, she filed and it was thrown out because Judge Lyman said, no, you're going to have to do this properly. She was seeking, I think it was 1.7 million for, again, dismissal of defamation, because that's what anti-SLAPP applies to. It doesn't apply to anything else. It applies to the defamation and being dismissed from a defamation lawsuit. Exactly the same as Section 47.1. Now, how Leslie Sloan managed to rack up 1.7 million in fees just for that motion to dismiss against a defamation cause of action, I have no idea. I think that's overinflated. And if that's her fees, I'm expecting Lively to come in with more. And then we got Lively is seeking the same Section 47.1 recovery from Jed Wallace, and she has already cited on that docket $800,000. But there's a difference there in that Lively had to file 2 motions to dismiss. So once they briefed the first one, Wallace amended his complaint, and then they had to rebrief motion to dismiss again based on the new complaint. And logic would say, well, look, she was eventually successfully dismissed and probably would have been, dismissed from the first complaint as well. So I would, in the worst case scenario, expect her to get fees for both if she's successful at all on Section 47.1. I would expect her to get the fees for both. But in the best case scenario, if she's successful on Section 47.1 in Texas, then she would get one set of fees. But she is seeking $800,000 for 2 motions to dismiss briefings. So how is she going to get to anywhere near Leslie Sloan's? How did Leslie Sloan even get there? And I think there's one way in which, people haven't really thought about, which would be it would be one way of doing it that might fly under the radar. So instead of trying to claim for a bunch of stuff, which Wayfarer can clearly go in and go, hold on a minute, that's just ridiculous. That's, over the top, that's overpriced. You don't need to have done all that work, right? Too many people working, etc., and pulling it apart. I don't know how either Manat or Wilkie have got their client files set up for Reynolds and Lively. Okay, they represent both parties. Both parties are married, and in law firms, you can either have individual client accounts for each person, or you can have them on a joint if you are, kind of dealing with the same or a similar cause of action. So if the matter is the same, say they're both being sued for, I don't know, you painted your fence the wrong color, and someone's suing both people as joint homeowners, then you can set up a client account file for both of them. Now, I look at the language that Manat uses in particular, right, throughout this entire case. So this is one of the earliest letters. This is January 2025. Yeah, January 24th, 2025. Before Wayfarer even amended their complaint. And as you can see, she refers to them as the Lively Reynolds parties. And there were several filings where they were done as joint parties, right? Like the sanctions, some of the motions to compel, they were referred to as the Lively Reynolds parties. And that actually kept happening even after Ryan Reynolds was dismissed. This letter is dated June 16th, 2025, 1 week after Judge Lyman ordered Ryan Reynolds dismissed as a party. Okay. Now, the reasons why we would need separate motions to dismiss for each party is quite clear. They're not necessarily in Wayfarer's complaint, they're not necessarily facing the same causes of action. Now, they were both facing defamation, which is the relevant one, but they would have both wanted to be dismissed for separate reasons, right? Ryan Reynolds, he was being sued for defamation for entirely different statements to what Blake Lively had put in her CRD or in the New York Times. Right, Ryan Reynolds was being sued for statements he allegedly made to WME or to Justin Baldoni's agent, etc. So he would have a different response to be dismissed, and each party seeking to be dismissed needs to, kind of persuade the judge of that. They need to make that argument, based on their own circumstances and their own defenses. So if we go back here, so this is Blake Lively's. This is not the memorandum. This is just the notice, right? It was written by Ezra Hudson, which would make sense. Ezra Hudson is the California attorney that is out of Blake Lively's attorneys. Ezra Hudson, Manat, they were dealing with California law. I think Gottlieb is admitted to the California bar. I know he's admitted to multiple bars. I want to definitely New York. So they brought in Wilkie for New York law, and Gottlieb was working for Wilkie. But I do think I've read somewhere he's also admitted to California bar and somewhere else, possibly DC. But don't quote me on that. I know he's admitted to at least 3 bars. So it would make sense that they're dealing with California Civil Code, Section 47.1. This is the first time we all heard about it. Ezra Hudson wrote the motion to dismiss. So why could we will be waiting. Why would Lively be like, we need Gottlieb here? Well, Gottlieb wrote Ryan Reynolds' motion to dismiss 2 days before Lively. At least he's the one who signed it anyway. It could be, depending on how their computers are set up, these motions to dismiss were filed within 2 days of each other. Now, when I think of Manat, obviously they are the architect and, the instigator of the Van Zandt Sham lawsuit, where they were quite happy to kind of bend rules and, not play fair. And I would think, well, if they're going to do anything, could they potentially, could they potentially move the costs and fees associated with Ryan Reynolds' motion to dismiss and kind of merge it with Blake Lively? And it would be quite difficult to tell, which one belongs to which, depending on how the client file is set up or how it's tweaked even in preparation for this. Now, again, I want to be really clear. I'm not alleging anything. I'm not accusing anything. I'm just saying they are definitely, capable of shady shit. They have been called out on it time and time again, right? And I don't trust them at all from my own personal experience. Let's go through that because, everything is my opinion. But, like, if we come back to this letter again, this is after Ryan Reynolds was dismissed as a party. But it didn't stop there. This kind of merging and treating them as one kind of entity. So this is the X subpoena, the one I was on, okay? It is dated the 3rd of July and signed by Ezra Hudson. So I'm just going to skip past. I've got a few things highlighted, but I'm just to show you. There I am. Production number 10. My spelt wrong X username is missing the 1 at the end, which I did actually put in my motion to quash. I referenced that. If I go back up though, I mean, this asks for all kinds of stuff, it really, really does. So like, his email, social networking sites, blogging and forum sites, advertising, promotional services, automated or third-party content management tools, any other online presence. Like, how wide is that? Anything that where I have, anything involving original posts, reposts, shares, likes, comments, hashtags, memes, images, videos, stories, threads, reactions, all drafts and deleted posts, or unpublished content, anything that relates to them, blah, 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 blah. It's just absolutely ridiculous. And as you saw, they wanted my bank account and everything else. So did I just go past it? Yes, I did. Got so excited. So here, they're talking about digital campaign, refers to the efforts of Wayfarer dependents and or any affiliates, employees, associates or subcontractors to communicate information regarding Blake Lively, Ryan Reynolds, the Lively Reynolds companies and the Lively Reynolds family. So when they're talking about the companies and the family, they are referred to as the Lively Reynolds. And then here, the Lively Reynolds companies shall refer to Miss Lively and Mr. Reynolds' affiliated entities, including but not limited to, and they include Betty Buzz and Blake Brown, Blake Lively's companies. They also include Aviation Gin, Mint Mobile, and Maximum Effort Productions. Okay, so they're Ryan Reynolds companies, obviously. Here, this is a bit, we all took issue with this, right? And I'll show you how we dealt with this. Mr. Reynolds shall refer to Ryan Reynolds, who is a party to this action. And what confused us is how? How a subpoena a month after he's been dismissed is he still being referred to a party in this action? And we want one better than that. So this is my motion to quash. And if we could scroll down a bit, I do actually call this crap out in the most snarkiest way, because that's how I deal with it. And I say, Given Mr. Reynolds was dismissed as a party on the 9th of June, I find it concerning that he is referred to as a party in this action within the definitions of a subpoena dated the 3rd of July 2025. And I attach the subpoena. This seems at odds with the court's order dated 9th of June 2025, and as far as the content creators are aware, Mr. Reynolds is not alleging any untraceable retaliation campaign for raising allegations of sexual harassment. And what I was saying is look, Blake Lively may be protected. Ryan Reynolds ain't. He's not raised any concerns regarding a retaliation campaign. He's definitely not done it because he spoke out about his experience of sexual harassment on the workplace. So why is he in here? Why is he in here? And I think it just made no sense. Like this, they were constantly being referred to all the way through his lawsuit as, one client. And I was like, I'm sitting here now thinking, well, if they were to try and pad the fees, the most simple way to do it, which would be quite difficult to, provably untangle, is to just bill for them as one client. And hide. You might not get away with, all of it, but you could certainly throw some in there. And then sort of rely on arguments such as, well, Section 47.1 is it's really novel, it's new, we had to do a lot of research. That would be one way of doing it. So that's my thoughts. There was something else I wanted to talk about. Oh, yeah. I haven't paid for this, but I just want to put this out there. What? They've made up, according to the Daily Mail. I'm not paying. It's got a paywall. I'm not paying for it. But apparently, Blake Lively and Taylor Swift have had a reconciliation phone call. And apparently, she's now invited to the wedding. And Daily Mail is saying literally no one saw coming. Are you kidding? We were all saying this for ages. Like, as soon as this case is over, they'll be back to being best of buds. Because there is no way that Taylor Swift disapproves of the way that Blake Lively has acted. She doesn't disapprove of stealing someone else's shit. She's not going to call her out because it doesn't seem like she's any better. It seems like she is quite a mean person herself. Apparently the actress had a dress picked out. Well, there we go. So, I'm sure we'll find out. I honestly think that this wedding is probably as much of a sham as the Van Zandt lawsuit, but, it's one area of all of this I really couldn't give a shit about. Like, if she wants to marry someone, fine, have at it. But yeah, am I surprised that Taylor Swift and Blake Lively could have made up now after all of this crap? No, I'm not. I don't think anyone is. So let me know what you guys think, though.